SwayamPrabha. Digital India. Educated India.
Well, students, this is Dr. Ajay Kumar Singh, Assistant Professor, Faculty of Law, BHU. This is my 10th lecture. I am going to discuss about domestic violence against women and human rights issues. So, in this lecture, I will try to highlight statutory provisions as well as constitutional provisions for the protection of rights of women, and Indian Parliament has enacted a special legislation for the protection of rights of women. So, you see, the topic is domestic violence against women and human rights issues. So, it is pertinent to mention that what is meaning of domestic violence, and then after you all would be in position to understand that how far this statute has been effective in protection of rights of Indian women. So, let us understand this domestic violence. You see, section 3 of this statute, section 3 of Protection of Women from Domestic Violence Act 2005, as I have already highlighted, the Protection of Women from Domestic Violence Act 2005. Considering the plight of Indian women and their rights, Indian Parliament enacted a special legislation, and that is Protection of Women from Domestic Violence Act 2005. Section 3 of this act talks about domestic violence, and you see this is more wider, section 3 is more wider term. It has covered each and every aspect of domestic violence, not only physical cruelty, but even verbal abuse has also been covered within ambit of domestic violence. So, according to section 3 of Domestic Violence Act 2005, any word spoken by respondent which is ridiculous, degrading, or any emotional abuse or financial abuse will amount to domestic violence. Where any statement which is made by husband against his wife which is ridiculous, degrading, which degrade the dignity of that female, which undermines the dignity of female, which is derogatory, even that statement will come within ambit of domestic violence, and domestic violence, aggrieved of domestic violence can file complaint against her husband. Emotional abuse, verbal abuse, financial abuse, all kinds of abuse which undermines dignity of female has been covered under section 3 of this Domestic Violence Act. So, you can understand this with the help of example. Emotional abuse, where husband or his relatives, mother or father-in-law of that wife, if they are making allegation against that aggrieved female that she cannot conceive a child, even that kind of allegation will be considered as domestic violence. Financial abuse here means where female is deprived from her financial right. She is asking money from her husband, and husband is not providing financial assistance to his wife, even that will amount to domestic violence. reasonable amount which wife is claiming against her husband and husband denies, then it will come within ambit of domestic violence. Once application is made by aggrieved female that husband has failed to provide financial assistance to his wife on a particular date and time, then that application would be considered as a complaint under Domestic Violence Act 2005. You all might be knowing that every married woman has a right to live with human dignity. She has right to be treated equally. This right to equality is human right guaranteed under Article 1 of the UDHR 1948, as well as right to equality is a fundamental right guaranteed under Article 14 of the Indian Constitution. So, all human beings are equal by birth. Every woman is entitled to live with human dignity, right to education, equal pay for equal work. These are fundamental rights which a female can claim, which female women are also entitled to get all these fundamental rights, human rights. In the light of these human rights, in the light of Universal Declaration of Human Rights 1948, in the light of Part 3rd of the Indian Constitution which talks about fundamental rights, we will have to observe the efficacy of statutory provision, how far this statute protection of women from Domestic Violence Act 2005 has been effective in protection of women's right. So, let us start statutory provision. What are the statutory provisions in this statute where female is entitled to get benefit under this statute? The first important right which aggrieved can claim under this act, Domestic Violence Act 2005, that is residence order. Residence order. Section 18 of this act talks about residence order, where domestic violence occurs, take place, and application is made to magistrate. Judicial magistrate first class is competent authority to accept a complaint, to accept an application under this act. So, where application is made to judicial magistrate first class, that aggrieved and respondent, they are living in domestic relationship as a husband and wife, as a sister and brother, as a mother and son or daughter. Judicial magistrate, after due inquiry here means after verifying the allegations, where allegations are true. So, if judicial magistrate is convinced that allegations are true, then he may pass an order in favor of that aggrieved. The important thing is, which you need to understand, that generally when Domestic Violence Act is referred, it comes into the mind of people that this act is only applicable for married women and a wife can claim protection provided in this statute against her husband only, and only wife is victim. But this is a wrong notion, this is a misconception about this act. You see, the beauty of this act is a sister can also file complaint against her brother, where brother has committed domestic violence against his sister. A mother can file a complaint against her son or daughter if her son or daughter has committed domestic violence, where son has failed to provide financial assistance to his mother. Mother can make an application to judicial magistrate that domestic violence has been committed, and that case would be definitely considered as case of domestic violence. So, now you see the aggrieved according to this act is married women, wife against her husband, son or daughter. Mother can also file a complaint of domestic violence against her son or daughter, where daughter is not providing financial assistance, committing cruelty. That matter will be covered under this act. So, what I am trying to justify, not only a wife, but mother, sister, they are also entitled to make an application of domestic violence against husband. Sister can file complaint against brother, mother can file complaint against her daughter or son. So, they are entitled to get benefit under Domestic Violence Act 2005. So, where aggrieved has come before the court seeking remedy for residence, and judicial magistrate is convinced under section 18 of this act that aggrieved should be allowed residence order, should be allowed to live in that house where respondent is residing, that magistrate may pass order in favor of aggrieved, allowing her to reside in the same house where respondent is residing. So, residence order is a first effective remedy in the hands of aggrieved. After having that order, aggrieved may live in that house where husband is residing. Mother can live in the same house where her or son are residing, and daughter or son, if they breach that order, it would be more harmful for the respondent, and the criminal proceeding might be initiated against them, they might be arrested and prosecuted. So, you see, this residence order may be passed in favor of aggrieved, and aggrieved after having this order may reside in the same house where respondent is residing. I have also highlighted section 16 of this act. Since domestic violence is a very sensitive issue between aggrieved and respondent, husband and wife, son and mother, daughter and mother, sister and brother. So, being sensitive matter, domestic cases relating to domestic violence that is decided in camera, in a closed house. Third party is not allowed to appear in courtroom. Generally, courts are open court, anyone can access to the justice, any person can enter into the premises of the court to see what is going on in the court. But cases pertaining to domestic violence, sexual offence, third party entry is prohibited. No third man, no third person can enter into the courtroom. Otherwise, except matrimonial dispute, except sexual dispute, except domestic violence dispute, anyone can enter into the court to see the court proceeding, that is their right. So, camera proceeding, the purpose behind conducting this procedure in a very closed house, in a very closed room, so that identity of that aggrieved or respondent may not be disclosed, because of right to privacy is a fundamental right. I have right to privacy, I have right that name not should be disclosed, I agreed the name of aggrieved, not the wrongdoer respondent should be disclosed. So, this is for that purpose, in order to maintain privacy, right to privacy, fundamental right. So, domestic violence case is conducted in camera, and residence order is also, you see, supported with bail bond. The respondent may be directed by the court to furnish a bail bond that you will not breach the order of the court. Whatever things are stated in the order, the respondent will have to furnish a bond to comply the content of the order, to comply that order, residence order, which a competent court, which magistrate has passed in favor of aggrieved. So, bond is executed by the respondent, by the wrongdoer, that is a guarantee. That is a kind of guarantee given on behalf of the accused, on behalf of the wrongdoer to the court, that he will comply your order, and in case of breach of this order, wrongdoer may be prosecuted and convicted for the breach of order. So, for that purpose, bond has to be executed by the respondent before the court. This is so, you see, this execution of bond by the respondent puts an obligation on the accused, the wrongdoer, that wrongdoer will follow the order, he will not breach the order, and in case of breach, he might be prosecuted and convicted. So, this is about your residence order. Now, come to second relief remedy, which aggrieved can claim against her husband, where married wife is deprived, domestic violence is committed by her husband, she can get relief from the court. The second important relief is protection order. Protection order, as I have highlighted on this screen, you just look at this. Magistrate may, after giving hearing, the word may suggests that he is not bound. Magistrate may, after giving hearing to aggrieved and respondent, giving hearing, this provision is based on principle of natural justice. No person shall be punished without unheard. No person shall be punished without giving opportunity of hearing to him. So, opportunity of hearing must be given before taking any decision. So, for that purpose, section 18 of this act talks about a wrongdoer as well as aggrieved must be given opportunity of hearing, so that they can represent their case before the court. If magistrate is satisfied that domestic violence has taken place, then he may pass protection order in favor of aggrieved. Protection order, you see, this is a kind of order, this is a kind of umbrella, protective order, this is a kind of umbrella which protect the aggrieved from rainy days. This order protect an aggrieved from any kind of unwanted attack from her husband. So, it works like an umbrella. So, after having this protection order, that aggrieved may be put in beneficial position. Protection order, what you see, protection order may contain certain requirement, may contain certain requisites. Magistrate, while passing protection order in favor of aggrieved female, may prevent her husband not to enter in that premises where aggrieved is residing. If she is working, then respondent may be prohibited from entering in the premises where she is working. In case of joint account holder, if husband and wife both have joint account in a bank, husband may also be prohibited not to operate that bank account. So, you see, these are the conditions which may be imposed by judicial magistrate while passing protection order in favor of aggrieved. So, you can see the beauty of this act is beauty of this legislation is this act provides immediate relief to the aggrieved in the name of a residence order. Respondent may be prohibited not to operate her account, joint account in a bank. He may also be prohibited from entering in the house where she is residing, entering in the premises where she is working. So, not to transfer the immobile property or movable property, where property which is jointly owned by aggrieved and husband and wife, where any property which is movable property or immovable property which is jointly owned by husband and wife, court may pass order that husband will not dispose of the property which belongs to his wife. So, he may also be prohibited not to transfer that property either by way of sale, by mortgage, by exchange, whatever methods are provided for the transfer of immovable property or movable property. Husband may be prohibited, respondent may be prohibited, a son can be prohibited to dispose of property of his father if mother has come before the court and mother is seeking remedy from the court that her son, her daughter should be prohibited from disposing of property of her father, mother. So, they may be protection order may be passed in favor of aggrieved. If there is apprehension in the mind of aggrieved that aggrieved female relatives, father or mother, sister might be influenced by the wrongdoer, or he may create, wrongdoer may create problem to brother, sister or mother, father of that aggrieved. So, in protection order, court may specifically specify that respondent will not commit any kind of wrongful act against the relatives of the aggrieved. So, even in protection order, court may specify that respondent will not commit any kind of illegal act against the relative of the aggrieved. Telephone, email, WhatsApp. You see, aggrieved may also argue before the court that respondent should be prohibited not to make any call on mobile, not to use any electronic means for calling her, WhatsApp, mobile phone or email. So, court may specify that respondent from today onwards, respondent shall not make any email to the aggrieved nor WhatsApp to the aggrieved. So, this kind of thing can also be specified, specifically stated in that protection order. After having that protection order, she can live peacefully in the same house where husband is residing, where mother after having this protection order can live in the same house where her son is residing, where her daughter is residing. This is the protection order which court can pass in favor of aggrieved after considering factors relevant. The third important thing is that monetary order. You see, monetary order where aggrieved has come before the court seeking monetary relief from her husband, mother has come before the court seeking monetary relief against her son or daughter. So, section 20 of this act empowers judicial magistrate to pass a monetary order in favor of aggrieved, considering the financial position of wrongdoer respondent. So, section 20 empowers magistrate may direct to the respondent that whatever loss she has suffered whatever medical expenses occur, whatever property has been destroyed by the wrongdoer, where movable or immovable property is destroyed by the wrongdoer, by respondent husband or son, court may pass order that the loss suffered by aggrieved must be compensated, must be provided by the respondent to the aggrieved. Adequate, fair and reasonable monetary relief, adequacy, whether monetary relief is adequate or not, it is a matter of fact that will be decided by the court on the basis of facts and circumstances, whatever loss he has suffered. So, monetary relief can also be given to aggrieved. Now, custody order. You see, I am talking about remedies available to an aggrieved under this Act, Domestic Violence Act 2005. Child custody, section 21 talks about child custody. Child custody. So, where aggrieved has come before the court seeking custody for her child or children, judicial magistrate, after considering the facts and circumstances of the case, may pass custody order in favor of aggrieved by stating that respondent may be allowed or may not be allowed to visit, or by magistrate. So, this kind of order, custody order, is always, you see, inclines toward female. So, court may also pass custody order where aggrieved has come before the court seeking relief for custody order. Now, come to this another kind of relief, that is compensation order. Compensation order is passed by magistrate in favor of aggrieved. Section 22 gives liberty to the magistrate to pass compensation order. As I have, you just look on section 22, mental torture, emotional distress, alteration in order, enhancement in amount, interim relief, ex parte order. So, I have categorized this in 4 category. I have mentioned the relevant statutory provision under which magistrate has got liberty, has power to pass compensation order. Section 22, ground on which magistrate can pass compensation order, that is mental torture, emotional distress which aggrieved has suffered, alteration in order, enhancement in compensation order. So, you see, compensation is always decided by the court on the basis of sufferings of the victim, on the basis of suffering of the aggrieved, what loss he has suffered, what mental agony or mental distress which she has suffered due to wrongful act of respondent. So, all these things are taken into account by the court while passing compensation order in favor of aggrieved. This you need to understand that compensation order is in addition to monetary relief. Monetary relief is that a different thing. Monetary order is passed in favor of aggrieved on the basis of expenses which she has spent on her medical expenses. In case of destruction of her movable property or immovable property. So, monetary relief is that is another thing, monetary order, and here compensatory order is. So, you need to understand that there is clear cut difference between compensation and financial assistance. The purpose of compensation is to put an aggrieved in that position in which he or she would have been if his or her right would not have been violated by the wrongdoer. So, the purpose of compensation is status quo ante. If I write this word, you may understand status quo ante. This is Latin word status quo ante. Status quo ante. It means to put an aggrieved in that position in which he or she would have been if his or her right would not have been violated by the respondent, by the wrongdoer. There are two things, status quo ante and status quo. You need to understand this. Mental agony, mental torture, emotional. It may also be enhanced. The amount of compensation may also be enhanced by the court, considering the financial position of the wrongdoer, respondent, where victim has come before the court for the enhancement of compensation order, and court is convinced that when order was passed in favor of aggrieved, the amount of compensation is not adequate. So, considering the amount of compensation, court may enhance the amount of compensation. Interim relief ex parte order is also where you see where respondent is not appearing in the court knowingly or unknowingly, then ex parte order may also be passed in favor of aggrieved. So, ex parte, and you all might be knowing that once caveat is filed, caveat as you all might be knowing that section 148A CPC, you all might be aware about this. Section 148A CPC talks about caveat. This is caveat. Once caveat is filed by a person, court cannot pass ex parte order. The purpose of filing caveat application is, just suppose if I have filed a caveat in the court, then court cannot pass any order without giving opportunity of hearing to me. So, this is the purpose of caveat. So, once this application is made in the civil court is bound to hear me, to give opportunity of hearing to me. Without that, court cannot pass ex parte order. So, the purpose of caveat is to prevent ex parte order. So, for that purpose this caveat application is filed before civil court. So, this is caveat. Now, come to this penalty for breach of protection order, where protection order is not followed by respondent. Respondent has failed to comply protection order in totality or any condition mentioned in protection order, it would be a breach of protection order and it would make him liable for breach of protection order. For that purpose, court concerned may initiate criminal proceeding against the respondent for non-compliance of protection order. So, he might be respondent might be prosecuted and convicted for the breach of protection order, and he may also be penalized for penalty. He may also be imposed penalty fine, that is 20,000 rupees. In order to make protection order more effective, this statute has made provision that the breach of protection order would be considered as cognizable offence, non-bailable. Once protection order is breached by respondent, it would be considered as heinous crime, it would be considered as cognizable offence. At that very moment, if application is made by aggrieved to the police that protection order has been breached by her husband, or mother has filed a complaint to the police that protection order has been breached by her son or daughter, at that very moment husband, son or daughter for breaching that protection order may be arrested. So, this is the nature of cognizable offence, seriousness of breach of protection order. Non-bailable. So, the person who has breached this protection order will not be allowed to get bail, will not be released on bail. The third important component of protection order, that it talks about speedy justice. You see, judicial magistrate, after accepting that application of domestic violence shall, the word shall has been used, he shall dispose of that case within 60 days from the date of receipt of the application. So, this time bound disposal of domestic violence case talks about speedy justice, which is mandate of Indian Constitution, speedy justice, speedy trial, that is fundamental right guaranteed under Article 21 of the Indian Constitution. So, in order to provide speedy justice to the aggrieved, this Act, Domestic Violence Act, has specifically provided that all the applications pertaining to domestic violence shall be disposed of within 60 days from the date of receipt of application. So, you see the consequences of breach of protection order would make the respondent liable for punishment, and it will also make him liable for penalty. 20,000 penalty may be imposed. It would make him liable for detention, he might be detained, arrested, and he shall not be allowed to get bail from the court concerned. So, this is all about your breach of protection order. You see how the beauty of this Act, Domestic Violence Act 2005. I have used this ADR in DV. With the help of this slide, I have made an attempt to apply this alternative dispute resolution method in domestic violence cases. This ADR here means alternative dispute resolution in domestic violence. You all might be knowing, you all might be aware about alternative method of dispute resolution, that is conciliation, arbitration, mediation. These are certain alternative dispute resolution methods. These are alternatives which aggrieved as well as a respondent can avail from the court. If this technique is adopted, ADR is allowed in domestic violence cases, it will not only reduce the pendency of cases from the court, but it would also be helpful to decide the cases, to dispose of the cases expeditiously. So, by doing so, we can reduce the pendency of criminal cases as well as civil cases. At the same time, we can also provide speedy justice to the victim, to the aggrieved. So, that is why I have chosen this ADR technique, ADR method in Domestic Violence Act. Now, let us see that where this method is specifically provided. You see section 14 of this Act talks about counseling. You just section 14 of Domestic Violence Act talks about counseling. So, counseling method gives an opportunity to both the parties, aggrieved as well as respondent, to come together to rethink over the matter, to reconsider about the grievances and about their disputes. So, through this counseling method, aggrieved and as well as respondent both are invited by the court to sit together and to resolve their dispute in healthy atmosphere. So, this initiative is adopted, this initiative is taken by the court, and aggrieved respondent both are, a date is fixed by the court. On a particular date and time, both the parties, aggrieved as well as wrongdoer respondent, have to appear on the date and time specified, prescribed by the court, and to resolve the disputes. So, this technique, you see, counseling is a process of ADR through which domestic violence case can be expeditiously disposed of, and victim aggrieved can be provided speedy justice by adopting this method. The maximum time limit provided in this statute is 2 months. You see, the magistrate shall fix the date of hearing within 2 months from the date of receipt of the application, 60 days. Where magistrate is convinced that both parties should be allowed to enter into counselling, both the parties should be allowed to enter into ADR, alternative dispute resolution method, because it would be beneficial for both the parties. Otherwise, unnecessary litigation will create problem for both the parties. So, considering all the relevant factors, judicial magistrate may allow to the parties to come together. The time is within 2 months from the date of receipt of the application. So, these are certain reliefs, these are certain remedies available in this statute, Domestic Violence Act 2005. The problem with this statute is the Domestic Violence Act 2005 and cruelty. The word cruelty has been defined under section 498A IPC. So, where physical cruelty is committed by husband against his wife, she can file complaint against her husband for commission of cruelty under section 498A IPC. On the other hand, she can file domestic violence, complaint of domestic violence before the court. So, which one is more effective, cruelty or domestic violence? You see, the cruelty which has been made an offence under section 498A IPC, Indian Penal Code. Nowadays, cases pertaining to cruelty is also clubbed with domestic violence cases, because this Domestic Violence Act and section 3 of domestic violence, which defines domestic violence, this provision is more wider than cruelty. So, aggrieved will always come to take shelter of this statutory provision, Domestic Violence Act 2005. But you see, the irony of this statute is, can you imagine an aggrieved who has obtained a residence order from the court. Court has allowed her to live in that house where husband is residing. Though act is very good and the spirit of the act is very good, the legislative intention is very clear that an aggrieved wife who has come before the court seeking residence order against her husband, a mother who has come before the court seeking residence order against her son or daughter should be allowed to reside in the same house where respondent is residing. So, can you imagine the danger or threat, the possibility or chances of threat to the life of that aggrieved will disappear just after obtaining the order from the court? It is not so, because a son who has committed cruelty, daughter who has committed physical cruelty against his mother or her mother, a husband who has committed physical torture, physical cruelty against his wife, will they allow, will they permit, will they give space, any space? And you see, the residence order which is supported with protection order once matter comes in the notice of the court, litigation always create problem. I am trying to highlight that is the social aspect of this act. This act is very effective, this act is very pious, the idea is very noble, but the practical or feasibility of this act is, viability of this statute is that aggrieved may always be in peril. See, or that aggrieved who has obtained order against respondent may not be safe. Why? Because there is no, statute is silent whether any police, any protection may be provided to that female who is residing in the same house where respondent is residing. So, act is silent, statute is silent. This statute also emphasizes that after having protection order or residence order, it is the duty of police officer of concerned area to designate any constable or any police personnel to make a visit to that house where aggrieved is residing and ring the bell. This is the slogan of this statute, ring the bell. That designated police constable will go to the house where aggrieved is residing and he will ring the bell, whether he will ask, that constable will ask whether she has any problem, whether she is safe or not, whether she is suffering any mental distress or agony, or any problem which husband has created, his son or daughter has created to that aggrieved. This provision has been incorporated in this statute due to judicial intervention. When judiciary intervened that if we really want to achieve the objective of Domestic Violence Act 2005, we will have this kind of mechanism. Station head officer SHO of concerned area police station will make sure that a constable or any police personnel should be designated by that SHO to ensure that to go to the house where aggrieved is residing. And it was the slogan when this act was enacted in the year of 2005 that ring the bell. Ring the bell means that designated government official, government personnel, and particularly it is the duty of SHO to engage a constable to visit the house of aggrieved, so that it can be ensured on behalf of government that life and limb of that aggrieved is not in peril or not in danger. So, this is the purpose behind making that slogan, and now that slogan has got statutory recognition for this Domestic Violence Act 2005, particularly for that aggrieved who has been tortured, who has been sufferer from her husband, or so in case of cruelty or physical torture, this kind of step is adopted by police officers. They can send any constable to visit the house of aggrieved, ring the bell, and this in this way we can achieve the objective of this statute. And second important thing which I want to discuss in this violence against women as and human right issues, you see, all women are entitled to live with human dignity, and in order to ensure that human right, in order to ensure that fundamental right as well, this statute, Domestic Violence Act, is primarily concerned with protection of rights of those female who have any grievances, who have any problem against husband or son or their daughter. So, and the most significant provision of this statute is that is alternative dispute resolution methods. After conducting conciliation method, after conducting counseling, arbitration, we can dispose of the cases of domestic violence and we can provide justice to the aggrieved within a specified time, and the time is 2 months, generally that is prescribed time by this statute, that is 60 days or 2 months. So, protection officer, you all might be aware about that state government can appoint any NGO as a protection officer. NGO must have experience regarding welfare of women. That NGO which has been working for women cause for more than 10 years for the betterment of women, for the betterment of female, that NGO should be allowed to work with government. So, even non-governmental organization NGO may be designated as service provider in this statute. That NGO may also play important role in protection of domestic violence. So, that NGO can prepare a report, that NGO can inform the authority concerned that order is not obeyed by followed by the respondent has failed to follow this order. So, even that NGO may also be given, because this act has permitted that NGO, non-governmental organization, may also be invited to assist the government. And you see many states have deputed NGOs for reporting the cases of domestic violence to the government concerned. And under this statute, NGO may get allowances and honorarium remuneration from the government. They NGOs, they can also play important role in protecting, in preventing this kind of incident, domestic violence incident, and it varies from state to state. But after the commencement of this Domestic Violence Act 2005, the ground reality is that we frequently, you might have seen that the incident regarding domestic violence cases are reported in newspaper or in print media, electronic media, and it is a matter of debate whether domestic violence, after the commencement of this act, the cases of domestic violence is on rise or decline. It is it may be matter of debate, and efficacy, so far as efficacy of this act is, whether this act is effective or not, it may be a question of debate. Before I conclude this lecture, I would like to highlight some. I have covered, you see, I have covered each and every aspect of remedies available in this act, like residence order, protection order, compensation order, custody order and monetary order. These are specific remedies which are available to the aggrieved female under this statute. So, after commencement of this statute, we can conclude that, can hope that we can say that this act has achieved its objective for which this act was enacted, and I have covered each and every aspect of grievances of aggrieved as per statutory provision and constitutional provision. what would be the consequences of breach of protection order? I have also highlighted that alternative dispute resolution method. So, with this I would like to conclude this lecture. Thank you.
Hello, I am Shikha Dikshit. I teach psychology and I am with the Department of Humanities and Social Sciences at IIT Kanpur. Today I am going to talk about what is health psychology. In the recent past, health psychology has emerged as one of the important areas in psychology. It is a field of study where psychological theories and concepts are applied to understand issues regarding health and illness. The two major themes which health psychologists are interested in studying are the themes of illness experience and behaviors associated with that experience. Contemporary health psychology adopts various and diverse kind of perspectives to understand health and illness issues. These perspectives include the behavioral perspective, the societal perspective and the cultural perspective. If we try to enumerate the kind of topics that health psychologists study, the range is very wide. To name a few of the topics, health psychologists study cognitions related to illness, that is health and illness related cognitions, social cognitive aspects of health and illness, cognitive adaptation, chronic illness and adaptation to chronic illness, disability, stress and management of stress. Health psychologists also study topics such as health related quality of life, social support and various kinds of coping mechanisms that people adopt to deal with illness experience. In addition to this kind of experience, health psychologists also study healthcare systems, health promotion and treatment related aspects including doctor-patient relationships. So, as we see, the range of topics is very large. Health psychologists also use qualitative methods and they study topics such as narratives of illness experience as well as social representations of health and illness. So, we see that the range of these topics is very large. However, this is not an exhaustive list. More recently, some health psychologists have adopted a critical health psychology approach. These health psychologists are, they offer a critique of mainly of the biomedical and behavioral perspective of health and illness as well as the methods and approach which is used to understand health and illness. So, critical health psychologists focus on the social, cultural and political aspects of health issues. If we look at the methodological aspects, overall health psychologists adopt quantitative methodology, they also use qualitative methodology and many health psychologists use the mixed method approach.